Memo akwaba eba court nkomo TV so me pacho di kan like page no na subscribe page no na share page no efa ma onua. Uria adoma ketewa na ewo nchen ho no pacho mia so. Umia so a video bi a court nkomo TV ye de beto ho no. Obenya bi ahwe na watimi awoso de ama onua. Uria na waja comment nso wase. Ebekenkan ni nyina na yada wase. Yemure Supreme Court and Yebore Supreme Court there a year watch ni Justice Abdulai wachradie it was UPSA in a ode asem kodan Supreme Court say Supreme Court ba so be dweku edi kan tena ase no na district ni say court no enhwe na oncheche article 104 mu ni nyina ene say article 104(2) no HPF says obi a deputy speaker of parliament na oni ho kwan say oto aba ema yekenkan no edeka ho eno na bra ni Justice Abdulai edi kan edekopie mu wo court no eka che ne say papai deputy speaker bia wo ho kwan so oto aba ma yekenkan no essence ono so ogina ho ema na de hye titiru ni Joseph Asewusu a na sabre no watna akonwam se speaker ewo mrahye bedwafiem ma yato aba agi e-levy edi atum eho so trobo ne ho deda ekoso eno enene dey Justice Abdulai esande nkrata afoforo ebedan Supreme Court batan say omo review omo decision ebeka say omo nsanse sa omo drink be ya esanse ne die ne dikan enipa enson eyatemuafo nson ene tena asinti yedi mienu beka ho ema omo ye enkron ene de enkron no atokrata ni nyina ato atwene eche say didikan enyina so papa bia enim ne toso mienu nso na ensese wode nkrata ne beto court no ohuri free station to station radio station as a TV station na all grant interviews isanse nkrata wode beto ho no na mistakes bebre ewo ma na atemuafo ni susu se otena ase eno ye nsisi ewo sankrata no de begu court ni ma kanu beboa ne sense oye media to eye dede neno na bra court no ekwa asetena wie yensam twofo ene Justice Abdulai etwetwe nkomo na ode tudwa se hu nye ni hu ne asi ni nyina no na onim se ebeba yentie Justice Abdulai nensem no ebi
prior to today I had made it clear that a review application is probably one of the most difficult things to succeed in at the Supreme Court, and so I knew the odds were against me. Indeed, some had predicted 1:100. I had predicted almost 0, except that I still moved forward with this because, in principle, as I said, I believe that the Supreme Court is made of seasoned lawyers, and if you make strong arguments before them, they were amenable to reviewing their decisions, their previous decisions. As it turns out, they decided otherwise. And once they've decided otherwise, I think we have to move on as a nation. What I didn't want was a situation where posterity would question us as to why we didn't take this small window of opportunity that was available to us to attempt a review for a possible review of the decision of the Supreme Court on the 9th of March. And so once they've decided this way, I think posterity will judge us all in a positive light, considering that we did everything that we ought to have done to get the sort of judgment that we needed. But this is what the Supreme Court says, and we all have to abide by that and live together as one nation going forward.
Thank you.
Enuachi enoba penia oye Deputy Attorney General Oba pa dapa Asonaba dapa Dina Asonaba dapa enso ne nsam twofo twetwe nkomo editu dwase ono nso de na onim se esi den a Supreme Court beto nkrata na twene esanse ne nyina so papa bia
I mean, Deputy AG,
yes,
I mean, are you satisfied with the outcome of the decision first?
Definitely satisfied, because it has been our position always that the review application filed by Justice Abdulai is unmeritorious and clearly an abuse of the process of the court. So yes, I am satisfied with the ruling of this honorable court.
I mean, from the process that he filed, I mean, do you think that had he marshaled those arguments in the initial matter, that could have perhaps, I mean, because the review window certainly is a smaller window.
Definitely. So as you heard the Honorable Court hold, the review application is very strict and the grounds clearly stated, and one needs to find his case within the threshold set for a review application, that exceptional circumstances which has occasioned a grave miscarriage of justice, and there are new information that has been discovered which was not present at the time of the determination. I do not think, even without going through the review application, any argument advanced by the plaintiff on the basis that the court ought to have had regard to previous constitutions and other statutes of the Commonwealth will still have held. As you clearly heard, our constitution, which is a written one, is sui generis and ought to be interpreted in accordance with its peculiar nature. And so reference to other constitutions, even previous constitution, is no basis for interpreting the constitution as we have it. And so clearly, those arguments, however they may have been raised, even with the initial...
Medase Sawaje Breni Adaji, na watch videos na watie Court Nkomo TV. But subscribe to our YouTube page, like the page, share the page, and leave your comments. Thank you so much. Be blessed.